Well, the most recent assignment was the case of the burglar and the bully. So there were some general considerations about crime that works through the criminal charge of burglary. And so I want to just read through the general considerations. If you're watching this on the recording, then um, see if you can open up the slide and read along with me. And if you're here live right now, please have the slide in front of you so we can read through it together, and I'll break down at various points, and then we'll take what we learned from these general considerations and we'll apply it to the case of the bully. So turning to the general considerations of crime. Every crime is defined by certain elements, meaning there are factors that must be met for each crime to constitute the crime that someone is being charged with. So each of which must be proven at trial in order to convict the offender. So in addition to proving any required mental state, meaning what the person was thinking, in other words, intent, the prosecutor must prove beyond a reasonable doubt, which is the standard, the burden that we've talked about, must prove beyond a reasonable doubt that the accused committed all of the elements of the crime. For example, and we're going to look at robbery. Robbery is defined as the unlawful taking and carrying away of goods or money. So taking or carrying away of goods meaning items or property or money from somebody's person by force or intimidation. And then these are the elements, therefore, of robbery. We see that there are three. One, the taking and carrying away of goods or money. The taking from someone's person. So person means their physical body. And three, the use of force or intimidation. So those items must be met in order for a jury to find the defendant, and I point over there because the defendant is always over there, unless they're over there, but for this purpose, they're over there. So must find those three elements for the jury. The jury must find beyond a reasonable doubt that they're guilty of those elements. So if someone breaks into your house when you are not home and takes your property, the person cannot be convicted of robbery. Why not? Why can they not be convicted of robbery? If the charge is robbery, what element is not satisfied? Someone breaks into your house when you are not home and takes your property. Why can they not be convicted of robbery? They didn't take it from a person's physical body. Exactly. So, faith. Well, Stephanie, it's not about witnesses. Remember, the elements don't say there has to be witnesses. For robbery, the taking from someone's person is required. So from someone's body. They broke into the house, no one was home. So they can't be convicted of robbery. But does that mean they are not going to go to jail? Does that mean they can do it? Can you break into someone's home and take their property? This means that if the charge that they are accused of is robbery, then they're not getting convicted. It means the prosecution has brought the wrong charge. They might want to bring a charge of stealing or a charge of thievery or some crime that meets the elements. The person can be convicted of burglary, larceny, but not robbery. Robbery requires the taking of the goods or money from the person's person. It's funny. So the person did not take the property from a person. No one was home. Therefore, could not be through force or intimidation. However, the person could be guilty of burglary, breaking and entering into a home with intent to commit a felony. right? To steal, to take goods or money, because the elements of that crime do not require the taking from a person or the use of force, which means we have to pause right now and we have to say, when we're talking about law and order, when we're talking about taking away someone's liberty for a crime, we have to charge them with the right crime. And so you have to pick the right charge. The prosecutor has to hear the facts for what the person has been arrested for, and then has to make the right charge. You just don't get to say stealing. They have to say burglary, robbery, larceny. It's a specific charge. And what is the significance of that? The significance is the different charges have different elements. And the different charges, therefore, have different penalties or different punishments that attach. So, very important to know. You have to pick the right crime. So, a single act, whoa, I need to go back. My thing got messed up. So a single act can be both a crime and a civil wrong. Wow, that's a piece of information we want to make sure we understand. So, for example, if Clay purposefully sets fire to Tamika's store, the state may file charges against Clay for arson, crime, arson, the setting purposefully setting on fire to someone's property. So that is a crime that the state may bring, that the government may bring against Clay, but also Tamika may bring a separate civil action against Clay to recover the damage to her store. So there may be two things going on here that we want to be aware of: criminal and civil crimes. So those are our general considerations. I'm ignoring the Mr. Burglary and Mr. Larceny. That's right. So now that we have these general considerations, I think we can summarize as follows. 1, each crime has its own specific elements. Even if they're similar crimes like robbery and burglary, they're very specific, and somebody needs to fulfill the elements of each one of those. So you want to know the elements, and what is being charged needs to be proved beyond a reasonable doubt to the jury. And so if the prosecutor picks the wrong crime to charge, then the person's going to be found not guilty because the elements can't be met. So crimes have elements. You need to pick the right charge. The burden of proof is beyond a reasonable doubt, which is not 100%. There can be doubts. It just can't be reasonable. And now we want to apply what we've learned to the case of the bully. And we've also learned that a single act can either be a crime or a civil violation. And so it's possible that it can be like arson. When you burn someone's house, that's a criminal offense as well as may hold you open to civil liability. So let's take a look at the application, the case of the bully, and see what we can work through here. Anton is a bully. One night while eating at a local diner, he notices Derek eating at a nearby table. Anton does not like the band displayed on Derek's t-shirt. Go figure. So to show his pals who is in charge, Anton orders Derek to sit at another table. Derek refuses. Anton just punches him right in the jaw. As a result of the injury, Derek misses several weeks of work and has to pay both medical and dental bills. And so we have a few questions we want to answer, and we'll just go down through these questions and apply what we've learned from the general considerations in the previous slide to see if we can determine various things about this behavior. So, has Anton violated civil laws, criminal laws, or both? What do you think? The band was probably Nickelback. Doesn't justify it. So, our question, has Anton violated civil or criminal laws, or both? What do you guys think? battery, assault. That's so battery and assault. You've identified some crimes, but right now the question is criminal or civil or both. So you're jumping ahead. You're jumping ahead by identifying the crimes. Let's go step by step. That would be like if this was a math question, then you're saying 27. That might be the right answer, but show me your work. Is this criminal, civil, or both? Julian says both. Bingo. You are math as well. You are what you learn. Yes. So Anton has committed both civil and criminal violations, assault, battery, and damage to the individual for the crime he has committed. So who decides whether Anton should be charged criminally? Let's work through that. Who decides whether Anton should be charged criminally? The prosecutor, society, the government. So how about if we break it down? Let me reference what is written here. Well, Derek decides whether or not to make a complaint to the police. Somebody can call the police, Derek can call the police, someone else can call the police, but Derek decides whether to make the complaint. The owner of the diner or other patrons may also call the police, right? The police report then goes to the prosecutor, as Julian points out. The prosecutor looks at the situation, and the prosecutor decides whether or not to charge Anton with a crime. So the prosecutor, that is the attorney working on behalf of the government, decides whether to prosecute the crime, looks at this and says, these are the elements to crime A, these are the elements to crime B. Derek wants to prosecute, wants to file, and the prosecutor says, yes, I have enough evidence to bring a charge. And so the prosecutor decides. Who decides if they're going to sue Anton for the damage to the jaw and the face and the missed work? Who decides that? Well, Anton is the one pushing or punching. So he's not going to say, I punched him, I'm going to sue myself. The victim decides. And in this case, it was Derek. Derek decides whether or not to bring a civil action. So a civil action is the most common way for a person who has suffered damages to recover money in our country. That's how it's done. So even without a lawsuit, if Anton is convicted in either an adult or juvenile criminal court, he'd usually be required to pay restitution. This is an interesting word. I'm going to write it down in the chat, restitution. So let's learn that word, that is trying to make whole. So Derek has been punched. Whether he's going to sue Anton or not, there may be victim funds that he's able to tap into from the community, from the city. But Derek's probably suing Anton here and suing him for damages. And let me ask you this. If you're Derek, from a strategic point of view, do you want to have your civil suit, the one where you're suing Anton, do you want that to come before the criminal case or after? Matthew says after. Anybody else? Albert says before. Okay, we got two different viewpoints here. So why do you think after or before? Why do you think that? What would be the advantage to bringing your civil case before? Other than you get it done, it's It's quick. It's easier to prove if done after. And Matthew, you're right. Almost always from a strategic point of view, before they get into full custody of the government. Hey, Albert, let's get this award quickly. And that's a good strategy. Probably not the most likely strategy. You probably want to wait till after, because if someone's been convicted of a crime, that means if Anton is convicted of this crime, right? Remember the burden of proof is beyond a reasonable doubt, where in the civil case it's only preponderance. So if you're arguing the civil case and you get to make the point, this person's already been convicted of the crime, it's a lesser standard here, so he should be liable as well. That's just an easier argument to make. I get your point about, hey, let's get the award before he has to spend all his money on his own defense. But what is Anton likely to do if he's found guilty of the crime and he's going to suffer criminal punishment? And now Anton is now Derek is going to sue Anton for the liability, and Derek already has a criminal conviction. Well, what is Anton most likely to try to do? You want this case to go to civil trial, where it's an even easier standard, and he'll almost certainly be found liable. Well, what's he likely to do? Can't repay debts from jail. You might be able to, actually, Julian. You may not make more money, but a check is a check if you got the dollars in the bank. And usually as part of restitution, if somebody's in prison and they're making money working some sort of job in the jail, some of their money that they produce can be garnished for restitution. But let's focus on my question right here, right now. You're Anton. You've been found guilty. You're suffering a criminal punishment. Derek now is suing you in a civil court for money damages. What are you probably gonna do? They cry. Yeah. I mean, you punched the guy in the mouth for not out of self-defense either. But do you want this to go to court? What can you do instead of going to court? What kind of alternative? This is our question letter D. Settle it. Excellent. So what does it mean to settle a case? What does it mean to settle? To come to an agreement, so you don't have to take it to court. So some sort of money agreement that would satisfy Derek. Now, if you're paying attention, if you're following along to all of this, let's see if you can answer this question. That's on the civil side, a settlement where Anton agrees to pay Derek some money that is going to satisfy Derek, and Derek will dismiss his case. What about on the criminal side? Can a settlement be reached on the criminal side? What do we call a settlement on the criminal side of things? So bail, well, bail is something very specific. You're charged with a crime and you're arrested and you're in jail. The trial that is set for you is 6 months away. Bail is a promise that you will show up in court to your trial if we don't keep you in jail. Because remember, in this country, you're innocent until proven guilty. So to keep somebody in jail until they're proven guilty is a complicated thing and could violate their civil rights. So bail is the money that you give to the court that if you disappear, you lose. So bail sort of promises that you'll show up for your trial. So bail gets you out of jail. Bail is set by the judge, even though it can be negotiated to be higher or lower, but it doesn't go to the merits of the crime. So what do we call it when the defendant settles? Like in the civil side, we call it a settlement that ends the case. When you hear the word, you go, oh, that's what it is. You've heard the word before. The word is a plea bargain. Have you heard that word before? Plea bargain? And so for a plea bargain, hey, I'm being delivered some coffee, but let's not pour it over my laptop. Let's pour it right there. And that's good, thank you. All right. Cheers, everybody. Ooh, that's hot coffee. It's good coffee too. So a plea bargain is the government saying, we have the evidence on you, we're going to take you to trial, and you're going to jail for 2 years for this. And we're going to seek the full 2-year punishment. And when we tell the judge what kind of punishment he should give you, we're going to request the maximum. Or you can plead guilty to this, and we'll ask the judge to only sentence you to 6 months. You'll spare the court all this time. You'll spare us the time of putting together the case, and you can agree to plead guilty. Have you heard of plea bargains before? So it's pressure that the government puts on somebody to confess to the crime for lesser punishment. It's the equivalent of a settlement on the civil side. I drink black coffee. I don't put anything in it. This is Pete's. That's what that is. For those of you watching on the recording, I was asked the question about what kind of coffee I drink. I wasn't just suddenly discussing the coffee. And this is a mug. Right? No, I'm staying on point. So the final question to address here is, because there is this criminal element that we've kind of worked through, and we've said it's almost certainly better to let the criminal case go before the civil case, even though Albert made an argument that does make sense for bringing the civil action first, but almost always you want the criminal case to go first, because even if the person's found innocent, you can still bring your civil case and say, maybe it doesn't rise to the burden of beyond a reasonable doubt, but we only have to prove beyond preponderance of the evidence. So we've learned that there's the criminal element and then the civil case, but here's my question. Can you bring the civil and criminal case together? Why do these two separate trials? Can't we just, look, Burglar, you've talked about settling on the civil side to speed things up. You talked about plea bargaining on the criminal side. Can't we just put these things together and have one trial? Can we do that? Wouldn't that make things a little bit more efficient? What do you think? Can we do that? Put them together? Don't we like to make things efficient? Well, somebody say yes or no. Let me know what you're thinking. Can we do it? We got one yes. We got one no. And let me ask you this. You take 5, 6, 7 classes as students. Wouldn't some of those classes, well, don't they kind of occasionally cover some of the same material? Maybe there's a little overlap, or maybe you're even working on some cross assignment for more than one class. But can you, and wouldn't it be most efficient to just do 4 classes the first hour? Let's just do them all together. The answer is no, you can't do that, because they're very distinct. They're different. They have different requirements. And just like you can't take multiple classes simultaneously because it would be more efficient, remember the criminal and civil cases are very different. The civil and criminal processes are separate. A civil action and a criminal charge can never be tried in one case. In a criminal case, the government's prosecutor brings the case to court and argues that the accused person committed a crime that is an offense against the state. In a civil case, a private party brings the lawsuit. There are also differences in the rules of evidence and procedures for civil and criminal cases. And as we discussed before, the most important difference is the burden of proof. So these have to be separate processes. So a lot going on here with this short little assignment. Very layered, very textured, but we're learning about crime, criminal behavior, charges that result in liability, either criminal punishment or civil liability. And we recognize that these are two separate processes that are distinct and separate and have to stay that way. So are there any questions as we wrap up our study of the criminal general considerations with the application to the case of the bully? No questions. We did kind of beat it down from all angles. So I'll go ahead and stop the recording. It was a pleasure working through our introduction into criminal law together.